And now our last speaker of this morning is Associate Professor Cătălin Rusu from Radboud University, Nijmegen. He will speak about the Commission communication after 10 years. What are the prospective enforcement priorities and challenges? I must add, maybe he will address in English. Yeah. He is Romanian born. He studied at the university in Cluj, but since several years now he is associate professor in the Netherlands. Please, Cătălin, the floor is yours.
Mulțumesc. Bună ziua. În primul rând aș vrea să mulțumesc organizatorilor pentru invitația de a discuta cu dumneavoastră niște teme interesante legate de dreptul concurenței. Cu voia dumneavoastră o să trec la limba engleză pentru că prezentarea a fost pregătită în limba engleză. Ladies and gentlemen, now, there are certain perks of being the last one to present at a conference, namely that you can always fall back and rely on what has been said before you, which I'm planning to do quite a bit. But there are also drawbacks, namely that certain topics that you would want to approach have already been preempted. So from this point of view, I will do my best to avoid annoying overlaps or repetitions. There is also the pressure to finish on time, and there's something that you should know about me. I always promise my students that I will finish on time with my lectures, and I never do. But I promise I will do my best right now. And this is because I like to have fun while teaching and presenting, and to be honest, competition law should be fun. So I would like to talk to you about certain fresh developments of competition law, namely the communication of the Commission relating to 10 years of antitrust enforcement under Regulation 1, certain priorities and certain challenges that I would like to discuss about. Now, as you may know, earlier this year, Commissioner Almunia put forward several documents which I find a very nice and neat way to wrap up his mandate. One of them pertains to merger control, which falls outside the ambit of this conference, but I'm sure there are interested people in concentration control in this room. It is very nice to look at the white paper, because the white paper on merger control puts forward certain interesting discussions and challenges relating to how the law should develop in the future. On a different note, the communication issued on the very same day falls somehow in a different category. It is not as straightforward as one may think. It's not the most engaging document that I've read from the Commission. And from this point of view, most of my conclusions that will be delivered today, or most of my statements, will be pretty much what can be read between the lines of the communication from the Commission. My conclusions pertain also to, or draw on, the latest speeches of Commissioner Almunia or Mr. Italianer, the Director General of DG Comp, because follow-up on this document is rather scarce at this point of view. So we have to rely on what we have. On a different note, the white paper on merger control actually seeks comments from stakeholders. So it seeks to engage the stakeholders in order to see how the future law on mergers or the merger control regulation will be shaped in order to include minority shareholdings. Now, to clarify things, the communication, its scope seems rather clear. It provides a facts-based review of public enforcement at EU level, so Regulation 1, and also certain interesting questions relating to enforcement by NCAs. Quite a bit of the discussion over here was previewed yesterday by Mr. Kiritsoiu, so again, I will not insist that much on these issues. The communication is accompanied by 2 staff working documents. Speaking of annoying repetition, you get quite a bit of repetition in the staff working documents, but also useful notions are explained in a bit more detail. So if you're interested in that, please double check, especially the second one, the second step working document pertaining to enforcement by NCAs. But bottom line, we have 10 years of enforcement experience at EU level, and the communication seeks to see how to further enhance this enforcement. Now, I have to say, it was a bit difficult for me to prepare this presentation because I was not certain that my place in this conference would be in this particular panel. But then again, when I looked at the schedule, I realized that it couldn't have been a better panel to schedule this presentation. And from this point of view, I chose to prepare the presentation in such a way to wrap up the conference, namely to look a bit at the past, to look at the recent past and present, and then to see what we can do to look at the future a bit. Now, with regard to the past, the value of Regulation 1 was over-discussed, and some say it cannot be doubted. It has given the Commission a greater scope to set its priorities and to set its enforcement in the key sectors of the economy. It has equipped the Commission with a new set of powers, built on a system that relies on, to a great extent, on the undertaking's self-assessment and then ex-post targeted enforcement action. Moreover, NCAs, domestic courts, have been involved in this whole process in the sense that right now Articles 101 and 102, as you already know, have to be applied in domestic ambits when trade between member states is affected. The value of the European Competition Network, the added value of the work of the Competition Network has to be brought in the discussion as well. Now, the communication takes stock of these developments. The exercise is done while looking at three perspectives, and you have them on the slide. So enforcement by type of infringements, focus on the specific sectors, and the types of procedures that have been used. Now, in the context of the performance of the Commission and of the NCA, certain interesting findings can be put forward. First of all, the communication sets clearly the statement that a large number of decisions have been taken by NCAs, much more than the Commission could have ever taken should decentralization have never taken place. Second of all, with regard to the type of the infringements, you will see both the Commission and the NCAs are after hardcore cartels and other forms of horizontal practices. What is interesting to note is that the numbers show a higher propensity of domestic authorities to tackle vertical transactions. Now, this may very well be a matter of coincidence, but at the same time, it may very well be the fact that the vertical block exemption regulation has worked well at EU level. But at the same time, to come back to what Professor Stauk had said, in certain member states, the block exemption regulation may apply in one way or another to purely internal situations as well. Article 102 is not that present in the enforcement as Article 101, on the other hand. However, you would see at European level the Commission going more over after exclusionary practices rather than exploitative practices. Okay, this may be the case that the Commission's 2009 guidance on enforcement priorities, again, has set the priorities correctly and has done the job right. But it may be also a matter of coincidence that domestic authorities go over or go against exclusionary behavior too. However, in domestic settings, exploitative practices are tackled more often than at European level. With regard to the specific sectors, you cannot really tell much of a difference. A broad range of sectors of the economy are tackled, from basic manufacturing industries to freshly liberalized markets, so not major differences over here. As far as procedures are concerned, you would see that the communication sets a clear preference to settlement and commitment procedures. And this is actually emphasized as well by Commissioner Almunia, who it is not once that he stated that he prefers these types of proceedings because they provide an efficient use of resources, speed, reaching a resolution of the problem in more cooperative basis. In the same vein, actually the Commission, in its communication, seems to provide a clearer indication on when prohibition decisions are likely to be adopted, namely when fines of past behavior, for past behavior should be imposed, when cessation of behavior is the only remedy available, or when there is a need for clear-cut legal precedent. This approach seems reasonable, but the question is whether this is sustainable in time or whether this will be followed through in the near future. For now, maybe. What have we learned from this experience? For now, we can conclude that we have 10 years of enforcement under Regulation 1, which witnessed the proliferation of competition enforcement. Now, the achievements so far have been based on reliance of multiple enforcers, which have guaranteed a wider application of the EU competition rules. In the words of the communication, and again emphasized by Commissioner Almunia, this system has not led to major gaps in the enforcement. Now, this is a matter of debate, of course, and you can find arguments in both, with regard to both sides of the story. But the issue that is important to raise is that a certain level of convergence has been reached as far as the application of the law is concerned. And Mr. Italianer actually identified 4 building blocks with regard to this convergence that lie at the basis of this convergence. And first one would be the joint enforcement of substantive rules, information exchanges between NCAs and the Commission, the European Competition Network and the system of reallocation of cases, and the notification of projected NCA decisions to the Commission. Some of these tools, some of these mechanisms have not been used that often, which the conclusion that the Commission draws is that this probably means that the system works well. In my opinion, observing these building blocks is important because it is a step in what can be labeled as achieving a common competition culture in Europe. By having parallel enforcement of the law, this approach is mutually reinforcing for the Commission and for the NCAs. Now, obviously, the goal of the Commission would be that in the coming years, this approach should be built on in order to have a genuine common enforcement area in Europe. Again, a matter that can be questioned or a matter that can be discussed in the future. What can be said to wrap up this slide is that we have some degree of convergence in substance, namely the application of article of the substance, articles 101 and 102, applying the same law, allowing at the same time fine-tuning of the law. And we have some degree of convergence in procedures as well. However, one can obviously realize that is a lesser degree of convergence when it comes to procedures. And this is where we can frame the discussion in matters of cause and effect, or cause and result. Well, first of all, first cause would be a lack of EU law provisions governing the institutional setup of NCAs, as opposed, let's say, to the fields of telecoms or energy, where EU law outlines somewhat more detailed requirements for the independence of national supervisory authorities. The result over here would be that independence is at risk, and this is where the Commission quotes overlapping competencies or problems regarding dismissals of heads of NCAs or other decision makers. Of course, you can have different types of relationship with the NCAs. The Commission communication also talks about merging several types of authorities into one, which is the example that we had in the Netherlands, and the risk over here being the type of spillovers that may occur over here. No specific European rules requiring adequate human resources or financial resources. There are also problems with enforcement priorities, setting enforcement priorities, problems with commitment decisions, problems with parent-daughter companies, liabilities, and so on. Now, the overall risk over here would be, in the words of Mr. Almunia, rolling back the substantive convergence that we have achieved so far. Now, what can we do in this respect? Is there anything that can be done? Well, the first question that we should ask here is whether there is room for more consistency in the procedural ambit. And the answer here should be yes and no. In my opinion, first, consistency should stem from the Commission as a trendsetter, if you will. But this may not necessarily be the case at all times. For example, in the communication, the value of settlement procedures and commitment procedures are praised. However, when we look at the responses that future Commissioner Ms. Vestager, when in the hearing in front of the Parliament, we will see, and I'm not going to quote right now, that although she appreciates this type of proceedings, she suggests that she will not compromise and she will prefer prohibition decisions when that is the case. This is not to say that we're dealing with a no-go situation as far as commitments are concerned, but a clear-cut preferences formulated for commitment decisions. Where should enforcement challenges lie in the future? Well, Mr. Kiritsoiu already told you yesterday about discussing about institutional position of NCAs, convergence of procedures, and effectiveness of sanctions. In this case, for example, the much discussed parent-daughter liability setting, again, the Commission can act as a trendsetter, and we have to look at the recent decision of Slovak Telekom being fined together with its parent, Deutsche Telekom, for abuse of dominance in the market. Again, this approach should be followed by NCAs in different member states too. Now, at EU level, to bounce back to the EU level, enforcement priorities seem rather clear, but there are still questions. I would have liked to read a bit more, although this is issue of public enforcement, I would have liked to read a bit more on private enforcement in this particular document and the relationship between public and private enforcement, also having in mind the idea of or the directive on private damages, the recent case law, namely pertaining also to leniency, Fleiderer, Donau-Chemie, Kone also. But it's also interesting to look at the situation from the perspective of the market players, especially when it comes to the Kone case. Because in my opinion, the Kone case changes the formula or the recipe of the prisoner's dilemma discussion. Right now, cartelists have to factor in extra damages that they are likely to pay in the near future should the umbrella pricing, or granted that the umbrella pricing discussion has been accepted. Although I would have liked to talk a bit more about this with you, I will wrap up this by saying that all in all, in my opinion, interesting and fun times ahead. Now, yesterday I collected a lot of cards from my distinguished colleagues, and I proudly told them that I do not play this game because I'm going digital. So right now, with many thanks for your attention and with the hope that what I said made sense, I will leave you with my contact details, and again, with many thanks for your attention.
Thank you very much, Professor. It was indeed, you managed very, very well to say the essential in the normal time.